May it be Lordship. May it be Lordship. Also, I beg to mention item number 34 here.
Adjourn.
Adjourn.
Interim is there. Interim is there.
34. No, my lord.
No.
34. Interim.
CD has been received. Adjourn for the day. Case diary be written. List on.
After puja vacation.
No interim.
No, my lord.
Can you retain the CD for so long? Adjourn for the day and praise for listing after the vacation. This is the case diary may be returned back and procured again for the next date. List on. Immediately after reopening, let us fix it. No? No, immediately after reopening. 15, 18 10.
Oblige. Deeply.
After 2. Second.
I pray for listing of an AB matter tomorrow if possible. Deeply obliged.
Is in custody. If it's not a custody, but in interim. Or is an interim, then no problem. Then you on the prayer of the learned council for the petition, list the matter after vacation. Any specific date? On 15? Yes, yes. On 15? 16. Okay, 16/10/2025. And the case diary has been received? Yes. You send back and send back to be procured again for the next step. The interim bail granted to the accused by the order dated so and so is extended till the next date of listing. Case diary not 27. Case diary not received. Interim is there. Interim extended till the next date of listing. Issue fresh reposition for the case diary. This also after vacation. There won't be much time. 15/10.
My lord.
Yeah.
In item 14, your lordship. In this case, I filed a affidavit reply, your lordship. Let it come and like in the case record. Kindly be taken to your lordship.
Today?
Today.
After 2. CD is not received. CD not received. Yeah, 49 case diary not received. Interim is there. Interim I'd order dated so and so. Status extended till next date of listing. Fixed on after vacation 16/10.
Lordship, I wait to mention item number 35.
Yes,
Case diary
not received. Yeah, case diary received. Are you on interim base? Are you on interim base? Let us fix it another day. Yes. This before vacation. So when should I fix it? 23rd? What was the item number?
35.
35. The prayer of the learned council matter adjourned for the day. Is there a receipt be retained? Adjourned for the day. Case diary. What should I say about case diary? 23rd, you can retain the case diary, perhaps, right? Case diary received be retained till the next date of listing fixed on 23/9. Okay. You're on interim, right? Madam, you're in interim? Interim?
Yes, yes, ma'am.
Interim bails by order date.
So in this case, civil no proceed.
Where?
Because open number 18 and 35, concern is that here, case number is.
Oh, I see. 35, this is CD is not received. So CD is not received. Okay. In that case, should we fix it after vacation?
No, before vacation.
Before vacation. 23rd,
23rd.
23rd, it may not come. CD, will it? Okay.
Lordship, it can fix after vacation.
Vacation also.
After vacation.
List, interim shall continue. List after vacation on 16/10. Okay, 16/10, interim will continue.
Maybe, maybe Sir Lordship, I am praying for a listing on IUI for order correction of Lordship.
28. Item 28, adjourned, fixed on. Fixed on 25/9/2025. Any interim?
May please, Your Lordship, I beg to mention item number 33, Lordship. Interim is there, Lordship. CD is not received.
Case diary not received. Issue fresh requisition. List after vacation on 16/10/2025.
Madam,
Any more mention?
may I please, Lordship, my lord, item number 42. Maybe adjourn for today, Lordship, and
42. Interim is there,
interim is there, Lordship.
then let us fix it next week.
Next to one of the vacation, it will
CD, that should be, what do you suggest? No, what do you
Yes, yes,
suggest?
that will be done.
42, adjourned for the day. CD received will be retained, list on 25/9, interim by order date shall continue till instead of listing.
The problem.
Item 68.
Just coming it.
Item 68.
68. Okay. For withdrawal, I mentioned for withdrawal.
Not sure.
You want to do it now? Now. Item 68. Mr. S. Munir, done it council. Praise for withdrawal of the petition, which is allowed. Bail petition stands disposed of on withdrawal.
Much obliged.
Naturally, I beg to mention for listing the anticipated bail application.
Listing?
Yes, sir.
Tomorrow. Today, or you want today or tomorrow?
Tomorrow.
Okay.
May I please, Your Lordship, can it be taken in the usual course? It's a hearing.
One is also my lord absent, and it will take some time now.
Hearing, actually, no, I had instructed to change, I'm not following the day before yesterday's sequence, I'm following the normal sequence.
My lord,
Bail matters followed by orders, admission and hearing
my lord.
in any case. So, what was the matter? No, number
52, my lord.
or supplementary? Or it
Main
came,
list, my lord.
in the supplementary list, my instruction came. But in the main list, it got published already. So, we'll look, think about it after vacation.
My lord.
You want an adjournment for the day? Or after vacation?
After vacation.
Item number
52.
motion. The prayer of the landed senior council. The 50, the matter is adjourned for the day. May be listed after vacation. Should I fix a date or
After vacation.
after vacation? The whole matter.
Obligation.
You want to,
Here, this matter already dispute has been resolved between the parties. The husband and wife, this dispute already resolved.
okay,
So if you lordship close this matter, then we should may see the. Here initially the dispute arose regarding Jima of Jim, which was in the name of the present petitioner. And the father-in-law wanted to get the Jima of the Jim. Accordingly, lordship, the petitioner filed a Jima before the court below. As the case was registered against them, that so police seized the Jim. Accordingly, he filed a Jima petition before the Learned CGM, and Learned CGM lordship allowed the Jima. And against that Jima order, they filed a revision before the Learned Session Judge. The Learned Session Judge upheld the order, but only direction was there that you execute a bank guarantee of ₹5 lakh. And thereafter, the direction was given to the IO to release give custody of the Jim to the present petitioner. Then what happened was that in between, lordship, his father-in-law died. That is the informant. He died, so he could not execute the bank guarantee within time. But as it was already directed to release him, the IO released the Jima and directed him to
execute the bank, guarantee,
execute the bank guarantee.
which however could not be done within the
Within the stipulated time. So they filed again one revision petition which was placed before the additional session judge, who hold that this cannot be done as there was a direction. So the order was there to register a complaint. So that is the case. So now already they have compromised the matter. So they are living together also. So that judgment can be set aside. So that where that direction was there, that your lordship will get. Annexure 6, page 37.
Mr. Ahmed, let's do one thing. I'll pass the order in second. We'll dispose it. We'll dispose it on the second. Let us go back to, there was a mix up actually. I had instructed, but it came later in the supplementary list. The main list, let us go back, start with bail, petitioner bails, orders. And then we'll try to touch this. Broadly, I have understood the basic facts. One, I can.
Yeah, Lordship. Lordship, will 483 application, my lord. Petition is behind the bar, is 13 days, my lord. FIR is just 11, Lord. The FIR has been lodged by the son of the petitioner, my lord. Due to misunderstanding, my lord, Lordship, Palace. Annexure 1, page 11, my lord. Married, my lord. Yeah. With due respect, I have the honor to state that I am living with my family at Guwahati for works. Since 17 days ago, my daughter Elizabeth 14 years come to our house at number 3, Bhelamari. And on last 11/9/24, my sister accused number 2 informed over phone that my daughter was missing from the house, and the above mentioned accused person physically assaulting my daughter since that day. And on last 12/9/2024, at about 5 p.m., the above mentioned accused number 2 informed on so at about 5 a.m. the accused Laili Begum informed my wife, namely Lakhi Kolita, over the phone that her daughter was lying dead on the pond situated east.
Tried it. You have children, sister, two children. We bought her and we bought her. You know, the accused call for the case diary of yes, number 97 of 2025. The accused is stated to have been arrested on 37 2025. Fixed on 24/9/2025. Case diary. 24.
I am obliged, Lordship.
Millet, make please allow. Millet, charges are serious, Millet. I believe Lordship may require recall case. Otherwise, I am behind the bars for 39 days almost.
Since
I am since behind
9/8.
Yeah.
9/8.
9/8.
9. Heard. Call for the case diary of Panbazar PS case number 259 of 2025. The accused stated you have been arrested on 9/8/25. Now I'll not go into it. Let's get the case diary.
My lord.
So when can we get?
Well, Panbazar PS, may I pray on 22nd?
Wait a second. I have no problem if it comes. If it comes, I have no problem.
But
Will it come?
Then my lord,
23rd,
then 25th.
25th. Okay. 25th will be near the vacation. If it
Well-
comes on 22nd.
Well, actually, I am,
23rd. No, no.
on
he has a problem.
23rd, I'll be out of.
Yeah, out of station. 25/9.
25.
May please. This is an application under section 483 of BNSF. FIR is page number 12, my lord.
He was later arrested,
Yes, my lord.
arrested on 21.
Arrested on 22.
22.
Arrest on 21 and forwarded 22.
20.
Yes, my lord.
Once we had seen the case diary. Call for the case diary again. Yes. Heard. Yes, Ahmed.
Yes, sir.
Call for the case diary of Ketri PS, right?
Chetri PS,
Ketri PS case number 61 of
61.
The accused is stated to have been arrested on 21/8 and first remanded on 22nd/8/2023. List on. Ketri. Let's try on 24. 24.
Published.
24/9.
Well, the petitioner was arrested on 26/8/2024. Today is 24 days. The case is that the informant is the owner of an excavator. And it was given to the FIR name case number 1 and 2 for work melody. And they have subsequently given the another person to work the excavator, hence the case number. The present petitioner though is not named in the FIR, but subsequently when the second agreement was executed, in his involvement shown in the forwarding report. And I think it is a civil national case.
Excavator
Not at all.
24 days.
Case for police custody. Heard anything and so. All for the case diary of Bogamuk PS case number 73 of 2024. Bogamuk of Dhemaji district. And so the accused was arrested on 26/8/2025. 25. 25.
Second time, Lordship have earlier rejected this case. Lordship, do a regular bail, may I pray for updated case there before the Lordship is possible.
Mr. S. Mudi, Learned Counsel, clearly submits that this is subsequent bail application. And prays for following the updated case diary. Call for the case diary of Bohist of PS case number 395 of 2020. The accused is in pre-trial detention pursuant to his arrest on 7/8/2020.
Lordship.
fixed on, let us get it on Tuesday or Wednesday. Wednesday, 24.
Much obliged, Your Lord. Much obliged.
But in this case, I'm not the engaging counsel. Well, Mr. Ed Iqbal, he is in out petition, he on request, well, I am submitting, that he requests me to submit on the court. The same matter is fixed on tomorrow, my lord, 3 items. Tomorrow's published 30, 31, 32. So maybe come up with that item 30 tomorrow. Tomorrow's list, my lord, in this court.
The prayer of the verdict. So, appearing on behalf of the leading counsel. Is this matter tomorrow? Along with.
Item number?
BA number is there. BA number is not there. Item number is
I, BA also, my lord, BA 2841,
2840.
oblique 25,
2020.
item 30.
In bracket, item 30 of tomorrow's list.
I am blessed.
Yeah, please, Your Lordship. Out of the same FIR, Lordship, two other bail applications are pending, where Lordship case diary was called for, and those were fixed on Lordship, 22nd. Same.
Call for the case diary of Navapera PS case number 24 of 2020. List on 22/9/2025. Do you have any case number? One will,
Along with 30 BA number,
one,
30,
one number will
yes,
BA
3034
3034.
of 25. I have.
This is a case of abandon of suicide, Lordship. So, Lordship, kindly call for case I,
Yes,
Lordship,
sir.
before vacation, Lordship.
What is your good name?
M. Decca, behalf of G. Bora.
M. Deca. But it's. Submits that. This case diary will be called. Call for the case diary of Samaguri PS case number 188 of 25. That's what, petitioner stated to have been arrested from 8/9 of 2020. Fix on Samaguri. No, no, Samaguri. Wednesday or Thursday? Yes. Thursday, 25. 25.
Let's Lordship.
The offense is of 3 years. The punishment is 3 years. Madam. I have behind bars for more than 50 days. So if the FI is at page 10, madam, if I may read. Yes, with due respect, would like to inform you that on last 9th morning around 10 AM, came to my jewelry shop located at Itakula Center along with one black color bait containing jewelry on the notice front of my shop laying dirty with garbage. While I went to bring water from another shop for cleaning, unknown left stand with 3 planes stolen my bag containing jewelry and departed from Sudia. And subsequently, these are the things. Now, I have been, there are 3 people, they are from, they were visiting Viswanath Chayani, they are from Orissa, they are hawkers. And they were arrested on 27/7/2025. Now they are behind bars. So if bail may be considered, your city is one.
They are. This, what is the allegation is about theft,
Yes, your
unknown thief.
yeah. The
Let us-
FIR is against unknown
Let us see the forwarding.
forwarding when it's at page.
They're, they seem that, they're from Orissa.
Yes, sure. They're small time hawkers. They go and travel and they. illegal kept on police remand for 5 years.
Be right. Let's see the case there. If it does not come, then let us review the matter, review the situation. Call for the case diary of Suti of case number 79 of 25. Those persons who are stated from Jajapur district in Odisha. Arrested on, they were arrested on
27/7.
27/7. 27/7. Can you get it on Tuesday, 23rd? Yes. This on 23. Much obliged.
This is the regular pay application. Lots of costs. Bail application were out of the same FIR, the lordship from the same police station was listed on
Today, this list
no, your lordship, priorly your lordship, on which the court was pleased to grant bail to interim protection, your lordship, to two of the petitioners therein, and was pleased to fix the matter on 24th, your lordship, for case diary. Also, I pray that the present matter may also be fixed for case diary on 24th.
no, that I can do. Are you seeking interim here also?
Lordship, since it is fixed on 24th, your lordship.
What?
As on date, your lordship, the
Same day.
petitioners are behind bars for 50 days and 59 days almost.
Who are they?
Lordship, the petitioner number one is the brother and the petitioner, elder brother, and the petitioner number two is the husband of the alleged victim. Your lordship, here, actually, the wife of petitioner number two had committed suicide, your lordship, and all the family members have been arraigned, your lordship.
If you can wait for 3 days, we can call the case diary.
Yes, sir, but lordship on 24th.
Wait.
Lordship may,
Also, you can keep that. I'll keep it. Call for the case diary of Moran case number 76 of 2025. The section is the present this person seeking bail arrested on 22/7 and on 31/7/2025 and 22/7/2025 respectively. Learned, your good name, please.
KJ Saikya.
KJ Circuit. Learned counsel submits that the petitioners, the bail preferred by two petitioners is fixed on 24/9. They have also been granted interim bail. Stop. Call for the case diary, case diary of Swansea Police Station. This is the matter on 24/9/2025, along with AB number 2278. Well, it will be different category columns, right? We just point it out on that list on 24/9. 24/9.
Deep privilege.
Make legal document. It is a regular bill application, but see the similar case is pending, there was called for name that is fixed on lordship 24/9/2023.
That is also regular bail.
That is also regular bill.
Oh, we'll fix it to it.
On 24 November, 24 November, along with the BN number 30.
Yeah, just a minute. Call for the case diary of Manipur case number 91 of 2024. The accused herein is stated to have been arrested on 2/9/25. List on 24/9/2025, along with
Along
DA
with-
number
3033. 2025. Plus.
Wait, please, your lordship. Lordship is that the report was called for the court to proceed. Only things is the lordship, the young boy and girl fall in love, lordship. The girl come to the house of this petitioner, lordship. His parents send her back, lordship. Thereafter, lordship.
Very good. You can get it.
Because lordship, this boy cannot staying in a home, lordship, because of that foolish harassment, lordship. They could not get the girl back, lordship.
Get the instruction. Can you get, not
At
after,
two, lordship, it's probable at two, lordship.
afternoon is possible? Take a chance.
At two, lordship.
Let us take a chance. Otherwise, tomorrow. I will not pass anyone. Time is. Yes.
May I please, your lordship? Your lordship, anticipatory bail application against an Aadhaar operator, your lordship. Earlier on one occasion,
Against what operator?
against an Aadhaar operator, your lordship. He holds a Aadhaar center, your
Aadhaar.
lordship, Aadhaar operator. Earlier on one occasion, the bail was rejected, your lordship, anticipatory bail. However, certain new developments have come up for which we are before this honorable court. Your lordship may kindly peruse the FIR, your lordship, with the page number
Rejected by.
rejected by your lordship, your lordship. May kindly peruse the FIR from page number 13, your lordship. From 13 onwards, your lordship. And the explanation part of the FIR is at page number
Just a
18.
minute. I'll remember. Next, then I'll peruse the FIR. Take a fresh view. Let's go back to the FIR.
Indeed, your lordship.
Page number.
Page number 13 onwards, but the main gist is at page number 18, your lordship. Page number 18, your lordship. May I read the contents, your lordship? Madam, with reference to the complaint from the Deputy Director, UIDA Regional Office, Guwahati, dated 11 June 2025, you are directed to lodge an FIR against the Aadhaar operator, Mr. Jairul Islam Talukdar, operator code, Aadhaar station of Dobokar, ward number 10, Hojai district, Assam. As per the said complaint, a verification and inspection conducted by UIDA revealed that Mr. Jairul Islam Talukdar allowed unauthorized operation of Aadhaar enrollment activities by his brother, Mr. Rafiqul Islam, who used a dummy finger and a photograph of iris to tamper biometric data and enroll residents fraudulently. Such actions are in gross violation of Aadhaar Regulations 2016 and guidelines issued under version 50 dated 12th March 2025, amounting to criminal misconduct, impression of forgery, dating data tampering and cheating, your lordship. So the said operator has been suspended for a period of 5 years with effect from 16/4/2025 to 15/4/2030 as per the AAN instructive action taken by UIDIA. In light of the above, you are directed to lodge an FIR and initiate necessary legal action under relevant sections of the BNSS Information Technology Act and Aadhaar Act, your lordship. So this is the gist of the FIR, your lordship. However, the previous circumstances which lead to the FIR, your lordship, will may kindly come to page number, the show cause notice, your lordship, page number 26, your lordship. From here, the main gist of the matter starts, your lordship, page number 26. This FIR was directed to be registered only after the person failed to reply to the show cause notice, your lordship. That was the action of the failure to comply with the show cause notice. A show cause notice was previously awarded to the or granted or allowed an opportunity to the accused person, your lordship. May I kindly come to page number 26, your lordship. May I read the show cause notice, your lordship? This is to bring to your notice that a complaint has been received by the Office of the Deputy Director, UIDA Regional Office, Guwahati, by letter number so, dated 11th June 2025, wherein it has been reported that you are indulged in gross misconduct and fraudulent activities in Aadhaar enrollment process. As per the said complaint, the subsequent inspection has been found that Aadhaar enrollment activities manner carried out at your center is unauthorized and fraudulent. Instead of you, your brother, Mr. Rafiqul Islam, was operating the Aadhaar enrollment machine using dummy finger and a photograph of iris to impersonate your biometrics. This act amounts to gross violation of the Aadhaar Regulation 2016 and the UIDS process standards and guidelines as prescribed in version 50. 4. The act of biometric tampering and impersonation is a serious breach of trust and security and attracts both financial and administrative penalties, indulging in your suspension as an operator for 5 years with effect from 16/4/2025 to 15/4/2030. This is the important part, your lordship. In light of the above, you are hereby called upon to show cause in writing within 3 days from the date of issue of this notice as to why appropriate legal and administrative action should not be initiated against you for the said misconduct and violation of UIDA guidelines, Your Lordship. This was issued, Your Lordship, on 11th of June 2025, Your Lordship, or 13th of June 2025, Your Lordship. And it was given a 3 days time from the date of issue of the notice, Your Lordship. And at that
FIR was lodged on, okay.
FIR was lodged later on, Your Lordship. This was the first opportunity which I was given. The allegation is that I have not complied with this opportunity, Your Lordship. My Lordship, may kindly come to page number 42, Your Lordship. Page number 40, Your Lordship. After this show cause notice, it was given that from the date of issue and not from the date of receipt, Your Lordship. And therefore, at that time when this show cause notice was issued against me, I was appearing in my examination at Guwahati, Your Lordship, where as the center is situated in Hoja, Your Lordship, page number 40 is the admit card and the dates are mentioned here, Your Lordship. At the date on which this show cause notice was issued with 3 days time, I was already appearing in my examination, Your Lordship. Thereafter, Your Lordship, even during my examination time, I took the pen and I replied to each and every point which was made out by the UIDA during the inspection, and I have already replied to the show cause notice also. And after that, Your Lordship, again, a 35(3) notice was issued by the police. Now, the matter from the previous bail rejection till now, we have come to know that both these notices were issued via WhatsApp, Your Lordship, and not in person, Your Lordship. The Supreme Court also have recently clarified that notices under section 35(3) and show cause notice have to be served in person, Your Lordship. Both these notices were received via WhatsApp, and at that time when I was appearing in my examination, because I am a student, Your Lordship. Now the question, indeed, the second part is
person is not in that location at the
indeed, Your
distance,
Lordship.
then also it has to be served personally.
It has to be either to a family member, Your Lordship. That has been clarified by Justice Sundar Kumar until judgment in 2025. Now,
That is your new ground.
Your Lordship, the second two grounds, Your Lordship, with regards to the allegation of iris and biometrics, Your Lordship, the thing with iris is simple, Your Lordship, it has to be biological. There is no picture in this entire world which can replicate an iris, Your Lordship. To use an iris, and the system which was already opened by this particular person, there was no enrollment going on when the UIDA got for verification, Your Lordship. And therefore, I was given an opportunity. I even replied to the show cause notice, but the time duration and the time frame was a bit delayed because I got the notice itself in a delayed manner, Your Lordship. And therefore, it is my humble submission that may I be allowed to appear and again submit the same before the police, Your Lordship. In the meantime, everything is there before in the petition, Your Lordship. Whatever I'll be stating before the police, I have given a detailed version and I cannot change my version now, Your Lordship.
Actually,
That is my
this notice is kind of administrative action.
indeed.
It's led to cancellation of this, suspension of this.
Indeed.
The criminal liability is parallel, related but parallel, right?
Criminal
So
liability.
anyway, I think I would agree with the prosecution. We'll try to do short date, but let us see the updated case diary quickly. Okay, we'll get an updated case diary, but try to get it quickly. Huh?
Your Lordship, now
No, in that case, it will be not justified since we, today I'm so inclined to grant interim. So therefore it will be better to try it. Will be overloaded, of course, from now onwards till 26th. So but try to get it. Try to get it. When can you get it? Mojai? Wednesday? 25. Heard. Reporter. So the land council really submits that this is a subsequent bail application seeking pre-arrest bail. The earlier petition was rejected by this court on what is the date of rejection?
4/8/2025.
4/8.
4/8/2025.
4/8/2025. It is submitted that there are some subsequent grounds. Which is briefly submitted to, which is briefly explained to the court by the learned counsels. However, the learned additional quickly submits that updated case diary may be looked at for passing in what. I will agree with that contention for the moment. I call for the case diary, call for the updated case diary of Yoboka PS case number 105
1092.
109 2025. List on 24/9. 24. Yes. 24/9.
Much obliged.
Try your best.
made previous lawsuit.
Yeah.
My lord, page 8 is the FIR. The FIR simply states that on the pretext of marriage, the accused was having physical relation with me. A major girl for last 3.
Not connected with the BA. It's not connected with the BA.
No, ma'am.
Listed below, just below 19 item. I thought, so it came in this column. Yeah, tell me.
My lord, the victim girl was, my lord, recovered, my lord. In the TCR, I have checked marked it. Victim girl was recovered. My lord, in the lawsuit order at paragraph 7, there is a, my lord, observation that no specific averment regarding.
No, I mentioned this. Yeah, this is the government. Some
My lord.
Some Supreme and another. 2014 5 GLR 193. Yes, ma'am. 2014, that's a slate and children.
So did my lord.
There was an earlier
Yes.
bigger division bench.
My lord.
XXX were X versus state of Assam.
Yes,
Just
I
slow
moved on to it.
So, Suomoto. So that was, it was from there, the principle was reflected. It's a short order. Anyway, so now he's on interim.
Yes, my lord, he's in interim, my lord.
Scan, give me, scan PCR. Scan PCR. You have flag marked something. You said you flag marked.
Yes, my, in the TCR, my lord.
Yeah.
Yeah. The 164 statement of the victim.
PCR. That's PCR. Let me have a look, and the prosecutor needs time and take out something. Otherwise, I can.
Prosecution may go to the TCR.
Very long, isn't it?
Isn't this incriminating?
No.
Many things.
Only allegation against the boy, my lord.
Anyway, I think we should give some time to prosecutor. You have a look also. He has stated about being taken to many places. Have a look, then we'll take it up on something. We'll take it up.
At 2 mile.
Okay, as per picture from the mother. But this is slightly incriminating, I find. Some, not slightly, little more. So incriminating things are there. See after see. There are 2, 3 statements, but and see the victim statements. Next. 1920.
May I please, Your Worship? My lord, the allegation is under section 108, abatement of suicide. My lord, your lordship may kindly take the FIR. FIR is at page 7. The petition, in first case, lordship, item number 19, he is behind the bar for 52 days. My lord, mandatory period is 60 days. And he has already completed 52 days. Your lordship will kindly come to page 17. Here, your lordship will find.
Page 7.
7, yes. Altogether, 4 accused are named in the FIR. Nuruddin Sarkar, he is the petitioner, lordship, he is behind the bar. May 2020. Oh, 90 days. And petitioner number, in accused number 2, 3, and 4, lordship, who is the father of the accused number 1, and others towards lordship, the paternal uncle. Well, they are in interim, and they have lordship appear before the eye, and the statement has already been recorded. Your lordship may kindly come to the allegation. May I read, lordship?
Yeah, please.
With due respect to state that his second daughter X had love relation with the accused number 1 since last 4 years and has established physical relation with her in various places with a promise to.
Your Lordship, in this case, the allegation is theft. The chase will check close to BNS. Your Lordship, in this place, police arrested me for 2 stolen motorcycle.
Motorcycle.
Which, yes, Your Lordship. Which police mentioned that they have recovered from my position. But Your Lordship, the actual fact is, police arrested me from Palton Bazaar, from my home place, and they just took me to 6 Mile, Borbari, and just advised by order me to just stay in front of 2 motorcycle, and thus they took a photo of mine, and they forwarded me with in other FIR, which was lost for the another motor vehicle, register number S01GA4425. But police recovered 2 other different motorcycle, which was not mentioned in the first FIR. And Your Lordship, police should have registered a so motor case from their own self, but they forwarded me with other FIR. And I am not the FIR name accused also. My name is not also mentioned in the first FIR. And Your Lordship, police mentioned in the forwarding report that time of the arrest is 3 AM, 1st of August. But police arrested me 6:30 PM of 31st July. And Your Lordship, today 48 days behind the bar.
48 days.
48 days, Your Lordship. Also, my humble submission, he's a local resident of Guwahati, and he's also a restaurant owner. Your Lordship, he will regularly appear before trial court. If Your Lordship granting bail. With any person, with any condition. Your
Restaurant.
Lordship. Your Lordship.
Restaurant only.
Yes, Your Lordship, the restaurant owner.
That is, yeah, some. Actually,
While doing investigation from the source information, while police arrested the present accused person, although the stolen vehicle mentioned in the FIR is not yet recovered, but while on being shown by the present accused, 2 other vehicles, stolen vehicles were recovered and being used by the present accused. Regarding that kind of seizure witnesses, independent seizure witnesses.
No, my lord, the FIR was lost for other FIR, other motor vehicles.
just I'll come back to you.
Regarding independent, civil witnesses statement is also available in the case.
Other vehicles.
Yes. other way.
And this vehicle which is mentioned, it's not recovered.
Not recovered, we will not investigation, some other vehicles recovered in presence of independent civil witnesses.
As led by this
As
person.
led by the prevention person.
Oh, my lord, the main
Let me
fact,
understand the things again from you. He was shown arrested.
yes, he was surrendered by other police station after 1 week.
But in this case, he was,
In this case, your lordship, in this case, when the police arrested my client, they arrested from Polton Bazaar and thus they took him to Borbari. And after that, they forwarded with this FIR, not after the inquiry, not after they find something. Your lordship, the main thing is the FIR was lost for the another motor vehicle. The registration number was 01GA4425, which was not recovered from his possession, or there is no any other proof that he stolen this motor vehicle. And police should have registered a suo motu case from their own. But police forwarded me with this FIR.
just here, just to find out one thing. In the forwarding report, they have mentioned that he's a habitual offender.
Yes.
Two aspects kindly see
Yes.
whether there is any material regarding that aspect, and
habitual-
secondly, involvement of a organized gang.
Yes, notorious kind of bike lifter, it is mentioned, most of the IO regarding that aspect is there. Regarding
Not only mentioned, some materials.
some regarding those case numbers, it is not.
No, your lordship, there is no material. Your lordship, there is no criminal record. There's no previous criminal record also. How they can accuse me that I am a notorious
No,
bike
that is
lifter?
true, that is true. Habitual offender term is a very serious connotation. Because it can be very, it can affect your right to get liberty or bail. So there should be some basis, even a GD entry.
Case number, I will have to.
But he's, that means what I understand is that he's suspected to be habitual.
Suspected, yes, your.
Because how will
Only
he know the, suppose the police say, how will he know the other two vehicles?
But his statement, last paper, his statement is there, his statement. Some of the. Boys of
No, he is not from Manipur, your lordship. He is from Guwahati. He's from he is a local resident of this place, Polton Bazaar. Yeah, your lordship, the main thing is,
vehicle
he
theft
was
is a-
arrested around 6:30 PM and they mentioned the arrest of time around 3 AM.
Other cases when there is no mention.
But the reference motorcycle in the FIR, that is not recovered.
Not
That is.
not this one.
Why in sorts of people, the present vehicle. Vehicles. This way, vehicles are also get vehicles.
Yeah. Materials. Bail is another issue, but there, no doubt that there's some materials. Third, the Wasim, Senate Council for the accused. The accused hearing is seeking regular bail in connection with Dispute Police Station, yes, Dispute PS number 622 of 2025. Under 303, subsection 2, yes. Is stated to have been arrested on 1/8/2020. The FIR was lodged, FIR dated so and so. Oh, 24/7/25 was lodged by the owner of one motorcycle bearing registration number A01 GA 4425 was stated to have been stolen when it was parked near a market. No person has been named in the FIR. The case diary has been received and the learned additional PP submits that two other bikes, two-wheeler bikes were recovered at the instance of the present accused. And that the FIR mentioned two-wheeler has not yet been recovered. TD has been placed before me, perused relevant materials, including the statement of the accused. In the forwarding, the IO has contended that the present petition, the accused is a habitual offender. And there is a wider racket, and part of a wider racket of bike lifters. However, learned additional people fairly submits that no case details been mentioned in this regard. Nevertheless, I find materials in the case there indicative of the involvement, primary PC indicative of the involvement or association of the present accused with other persons in theft of interstate theft of two-wheelers. At this stage, I deem it prudent to allow the investigation to be complete. According to the bail petition, despite the length of the case, stands rejected at this stage, return back the case there. Just let the investigation get complete. Then you can always, if it falls within vacation, you can approach lower court for statutory bail. Vehicle theft is a very serious offense. Many people buy vehicles with tremendous effort. Most people.
Item number 24 and 25, can it be after something?
You want to do? Would you like to do? Wait. You can start it and we can wait for your signal.
Okay.
I'll encourage you to. Don't worry. Something to be heard for. 24.
It was called for my, but my lord, in this case, my lord, petitioner has been a victim of a circumstances. Because his wife has committed suicide, my lord. And the fact situation, may I allow me?
Just a minute. Should I go through the FIR?
My,
I'll go through it myself.
page 15.
Wait,
Translate.
I'm
Or
reading. I'm reading. I remember.
argued on
Okay,
detail, my lord.
so
That's
sorry. So there's allegation that
my lord. And
she might have been killed out.
yes, ma'am.
Okay.
Murder. You may see that all the allegation, it's not, even not a cruelty.
Serious come. When was he arrested?
On 10,
8-9.
8, 9.
Has it progressed investigation? To some extent.
No, whether it is suicide or not, that is
That now the official report not yet received. Only
Have
the
no
PF
FIR.
report received, PF report is not received, 11,000.
Lordship may consider, because my lord, his father is my lord abnormal, my lord. No one is in the house, my lord, to look after my lord. This is
Some
the,
of the statement of the witness that they valid before the day of the incident, some there are witness statement people. It went for
Stated to be an alcoholic.
Yes, alcohol. And one unmarried sister of the mother, petitioner is also there, whether it's legal also there. Was otherwise, and they, before the day of the incident, some Israel was held residents of the petitioner.
my mother,
And they regarding my lord, some dispute regarding cooking my lord, between the sister of the present petitioner and the victim. And they two of the friends of the my lord deceased came to the residence of the petitioner for having dinner. And regarding some dispute occurred between the sister of the present petitioner and the victim deceased. And at that point of time, these are the statement, and then they know that the present petitioner also supported our sister because of only the allegations. Ultimately, the lordship may kindly believe a statement.
We can wait for some time, let the cause of death come.
Yes, sir.
At this
my lord,
stage.
my lord,
Must be. Because this aspect, after all, stage of, at this stage, the FIR is also important, right? Yes, everything cannot be said in the FIR too, but since there is one angle of allegation. So that it would be, I think, wiser to wait for the court.
in post, if there is a postmortem, my lord, whether there is any, my lord,
Death or hanging, right?
that is the main,
As far as I know, let's see. If it is indeed suicide, then aspects of it. We have to see whether there is any abatement. If it is not a suicide, then it becomes
yeah,
more serious,
yeah,
much more serious,
yes. Only the,
much more serious. So that's why I said, let us see.
and his, just his mother died, my lord. There is an emotional thing, my lord. And how the accused tell her sister,
Point said, the father is mentally
mentally
challenged.
Yeah.
Mentally challenged.
mental. And her mother, accused mother has died just before 1 month, my lord.
And is there any material, sufficient for that?
Yes, my,
Yes.
not my lord, mother,
Investigation regarding father?
death certificate, my lord.
No, father.
Father, I
See,
have not,
who's suffering from mental illness?
yes, he is under treatment because the accused, my lord, got the job, my lord, in the railway. His father's job.
Disability.
Yes. If required, kindly see the city, my lord, whether this is suicide or that is. And in the FIR itself said that the accused was sleeping in his bed and the wife committed suicide in the next room, my lord. And the accused abstained from the dinner itself in that day, my lord. He was sleeping, my lord. He does not know. In the FIR. Even when the police come, the accused does not know. He was sleeping at that time also. Police arrived after the accused, my lord. And after making the party, my lord, he committed suicide. This is absolutely, my lord, our own. And though I have not stated in the minor, my was he was treated under the psychologist also. That is one fact I have not disclosed that here now.
Alcohol problem, definitely, that's a disease in alcoholism. You heard the point. Learned counsel for the accused. Additional people, the accused Deepu Sundar Das is seeking bail in connection with Jalukbari PS 303 of 2025. He was arrested on 8/9/2025. And the
102.
the allegation is about cruelty upon his wife, who later committed suicide. It is also alleged in the FIR that that it is also alleged in the FIR by the informant, who is the brother of the deceased, that they suspect that his sister might have been murdered and body hung from ceiling fan to make it appear like a suicide poster. The case diary is received, and despite lapse of few days since registration of the FIR, there has been some progress in the investigation. However, prosecution submits that the FSL report and PM report. PM report is not conclusive. FSL report is awaited, and PM report is not conclusive regarding. Where is the PM report? PM report is the next statement. So before the envelope. Indicator, some indication can be given about antemortem hanging or postmortem hanging. Nothing is mentioned. The FSL report is awaited, and though post PM report is available, but the opinion regarding death is not is kept pending. Since there is an allegation about foul play also, and the proper opinion regarding death is still not available in these initial days, I deem it prudent to refuse bail at this stage.
Then till updated.
Find another one.
No, kindly,
Because
FSL may be
takes some
called for.
time.
FSL may be called. Please, kindly, 25, FSL may be called for, kindly, because the petitioner father condition, the family is in distance. His mother also died,
The learned counsel further submits that the bail petition may be kept pending at this stage, and while calling for the FSL report. And in this context, we submitted that the father of the accused, who's alone at home, is suffering from mental abnormality. What actually at this stage was not so justified. Again, it will come.
The fact situation, at least, consider, FSL.
So we'll keep pending. Return back the bail petition is kept pending. Return back the case diary, or you keep the case diary. Only a few days. Return back the case diary and the updated opinion regarding death and FSL, if available, may be procured along with the updated case diary. In the meantime, the petitioner side may submit medical documents if any of the mentally, of the supposed mentally ill father of the accused. Submit some documents.
And my lord, the
Then
service, my lord, because the petitioner got this.
other related documents.
Yes, my lord. Obliged.
List-
Obliged.
List on 25. I was not inclined to grant bail at this stage. Because at the very initial, they should have progressed for some time anyway.
Any date, my lord, they lost it 1 million.
25 or 24. We should not, we should keep these matters for 26. Because the new matters might come. 25. Change of
Obliged.
list on 25 9. Updated case there.
Certificate case, your lordship, second application. Yes, I am on non-compliance of 47 and 48 notice, your lordship.
Or second application.
Yes, your lordship, because earlier rejected,
Rejected in High Court.
lordship. I have annexed the order, your lordship. Order is on page number 34.
Mr. Goswami, this I had a look at there was pointed out, right? I had a look at the notification. They offered. So irrespective of the roster, it has to be listed before the earlier charge. Clause 3, the subsequent petition. There was some confusion. The roster is different. It may not be, but I checked it. You can refer to this. As the earlier bill petition was rejected on 25/6/2026 by another bench of this court. Therefore, in terms of point number 3 of notification number 27 dated 3/5/2025, the subsequent bill petition may be listed before the appropriate page. Okay, you can have should be available on our website.
I'll check it out.
For council also, it's helpful to have this. Third point, you say the bail of the said, the subsequent bail application, bail payer of the said, irrespective of the subject matter assigned to the said bench.
Apply, your lordship.
Should I have to give a date? Should I give a date? Automatically.
Apply, your lordship.
Actually, during an anticipatory bail application, during the pendency of the petition, charge sheet was submitted. As such, TCR was called for, and the same as duly received. Yeah, my lord, the FIR is at page 14, my lord.
Charge sheet.
It's charge sheet. During the pendency, my lord, charge sheet was submitted. Just may I read the FIR, my lord. Just
Mother and son.
mother and son.
Yeah.
May I read the FIR?
You want to submit or should I give it? Yeah, you can read.
With due respect, it is stated that about 8 years back, my daughter so-and-so was married with a younger brother of the accused number 1. Then, yes, 32 or something. The name of the petition is there at serial number 3.
Then your FIR
Page number 28, madam.
that also needs to see. Group fight.
Group fight.
22 on one side, accused name in the Aadhaar lost by your side, your client, Rahela Khatun.
Yes.
And the other against your Saiful Islam. He has names of 32 accused persons. Not easy to find out actually what this man is saying.
And
Anybody granted interim here?
absolute bails were granted, madam.
No,
I'm
you are-
not taking,
No, this is for not all.
not all. This is for case number 3.
Only three. One. Yeah, then we'll have to wait. Then we'll have to wait. Dhubri PS. Dhubri.
Statement in their injured statement.
Against him, any,
In the affair, my lord, only name of one Sher Ali. The Sher Ali statement is says that Sujabadi who expired. That is the allegation in the affair. Regarding two other injured persons, Saifur Ali and Aadhaar Ali is also there. Their statement is also available by Saifur Ali. They implicated the accused person Sabatullah was at that point of time he was and those other persons associated they assaulted he also assaulted one of the Indian persons regarding that statement.
it can be disposed of also. If you insist, then you can wait for the statement also. Otherwise, the materials are not in your favor. Not very much in your favor.
Yes, my lord. This is a case of lordship 103. I cannot claim parity. My lord.
Yeah,
Then another date may be fixed, my lord.
after some. Now you want to this matter to come up on the second half. Disposed of or late after vacation. Let us see. No, I can dispose of also. Then you give me the seat.
Yes.
Then in the second half, I'll dictate. But give me the seat. Actual part I can start.
His name is Malik Sabatullah. 64 statement of
These kind of things, there's risk on both sides, implications. You know, it's not easy to see the implications. Not easy. There are clear methods and other methods. Otherwise. Who I dictate.
Two other persons.
Later injury reports be called for, my lord. Let the matter be fixed after vacation. And these two persons, their bail was granted on 23/7/2025. And the
Otherwise, the witnesses, witnesses stated about
What is the name of such witness? No, we don't have.
One Saifur Ali, injured witness, he's 164 statement is also available.
But for only.
Saifur Ali.
And
One Zahar Ali, he's 164 not available. His statement is there, injured.
sir, I'll have a look, then we can then decide. Then go ahead to decide.
And it is taking up at two.
Some other witnesses.
Take it up to two. No further hearing is necessary. Just see if it can be disposed of. Otherwise, if I think it can be, it should be kept. Yes. Yep.
Regarding item number 70 to 73 of supplementary hearing,
Yes.
well, if the business of the court not permit them, better may come after vacation. Oh, 14 or 16,
72 and 73.
yes.
October. No, I have no problem. You just work it out. Make sure. Council submits that place for adjournment of this matter. And for it to be listed after the petition. Prayer is allowed. List the matter for hearing on 28/10/2020. In any case, today is unlikely to reach. We have a meeting, 4:30 otherwise. Not serious. Anything else?
Order. Maybe 1944 of 2025.
Petition is rejected.
Maybe 180 of 2025.
Supreme Court ruling is applicable since PNA has been issued. So anticipatory bail is rejected.
Maybe 218725.
Connected.
Maybe 2233. Maybe 2291.
The matters are rejected. So I do not find grounds to allow. To move.
Maybe 2788
Two connected petitions were here. The AB is dismissed. The BA is allowed.
Deep level.
It's an election. BA is allowed. Attention to this. Should I take up that matter?
31.
The case diary as called for has been received. Based on the case diary, the learned additional people submits that the investigation is not yet completed and in progress. Is in progress. And upon the case diary being produced before the court, I perused relevant portions thereof. So, in the alleged incident, there is stated to have been one death and also a victim suffering grievous injuries. It is the postmortem report and the findings and the nature of injuries therein are compatible with the alleged assault. This pointed out by the learned prosecution that there are implications against the present petitioner as well, and several witnesses have stated about his presence and involvement in the alleged offences. The FIR names several persons, including the present accused. In a case of this nature, where the alleged offences are stated to have taken place between two groups of persons, full stop, and resulting in death and severe injuries and grievous injuries, full stop. And keeping in mind that the investigation is still in progress, full stop, dash, the possibility of the requirement of custodial interrogation of the concerned persons cannot be ruled out altogether. Therefore, I am of the considered opinion that it may not be prudent to grant anticipatory bail at this stage of investigation. Accordingly, the bail petition stands rejected. Return back the case there. It will progress.
I have this.
It is disposed of.
May I please?
Left over.
This is regular bail application. Investigation is over perhaps.
They are different cases.
Well, different. Same accused.
Oh, same in different
Mine.
cases. Bail application.
Mala, bail application. Good.
What is the offense?
Say, under section 331, LARPing house trespass and theft in dwelling. 305 is 7 years up to 7 years and 331 up to 5 years. I have
Two accused persons here in
two accused,
Morino.
more accused. Well, 37 years.
The accused persons are seeking bail under 483 NSS in connection with Morino PS case number 167 of 25. They are stated to be in pre-trial detention upon arrest since 11 allegations are serious, but house trespass. These are very public safety issues.
Well, shown arrested. Here in this case, we have been shown.
What is the date of their arrest?
11/8/2000.
11/8/2000, since 11/8/2025. Mr. P. Botakur learned additional people submits that in the meantime, investigation has been completed in this case, resulting in a charge sheet against accused persons. The allegation was pertaining to house trespass and theft. What is your submission? You call for scan?
So yes, the way it seems to be still in the second case. Also.
The learned additional people opposes the bail application. Pointing out that there's more than one case pending against the accused. Nevertheless, considering the completion of investigation, I'm of the considered opinion that perhaps the accused can be given a chance at liberty by imposing suitable conditions. After imposing suitable conditions, in such view of the matter, allowed to go on bail, little more and given 30,000, but with one surety, like the satisfaction of the concerned learned people. Following conditions are imposed. Number one. We shall not abscond. We shall not hamper or tamper or delay. We shall not intimidate, harass, or try to influence the witnesses, including the informant. He shall not misuse his liberty to commit any offense or illegal activities. And in case of violation of bail conditions, the prosecution would be at liberty to move a suitable application for cancellation of the bail.
My lord.
The
My lord.
petition stands allowed in this procedure.
My lord.
Also giving inspection.
My lord, in item number 25, my lord, we are behind the bar since 47 days. 60 days is mandatory period, my lord.
It's over.
No, my lord. 47 days, my lord. Kindly for a moment, my lord. Page number 16, forwarding report.
Just
Ground number 2, my lord. Stolen articles we have recovered. Page number 16.
that multiple cases involved.
My lord,
Allegedly.
Is the CD number?
This CD not come.
47. 47.
So
So far the health condition.
you won't be able to go.
My lord,
Despite
already
getting
recovered.
bail.
So further custodial detention will not serve any purpose. Already stolen property recovered.
But it's better to see the case because the nature of the offense, especially. So, but before vacation. Yes. Before
Right.
vacation. Before vacation, otherwise. that will be-
Except
Hardly
26 any
meaningless.
days, my lord. Except 26 any.
No, 26 as such, we should not fix many cases because there may be new cases.
Except 26 any days. my lord. I will not be able.
It will depend on the 25 or 24. 24. Today.
Highly.
The case diary is not yet received. Issue a requisition for the updated case diary. Fix on 24/9/2022.
Highly.
Council again on behalf of the petitioner requesting.
After some time,
It is a crucial tomorrow, my lord. This have a seriously suffering from fever, my lord.
Oh.
After the court, my lord.
no problem. Yeah, he's not well.
My lord, tomorrow, my lord.
Tomorrow, we'll be able to come.
Yes.
Tomorrow, Monday might have been better. Actually. Yes. But anyway, it's up to you. This whole report was called for. Report was called.
As per my verbal instruction, there is no such case.
Okay, that is there in form,
Yes.
but will they send a report? No, they will send a report.
Verbal instruction, verbal solution against. But I will get by tomorrow. Monday.
Nah, up to you. Tomorrow I can fix.
Tomorrow.
Tomorrow, you want? It is submitted by, should I record that submission?
Yes.
It is submitted by people who learn it additional. That. As per verbal instruction, no case is pending against the petitioner in the state police station. However, it is informed by another learned counsel that the engaged counsel is not well, could not come for this hearing. And praise for facing it tomorrow. List on the learned additional meeting submit that we shall try to procure a written report. List tomorrow. 19 List on 19/9. Come and supplement this problem.
This year has been received, my lord.
Also, it's not
Already
time.
already gone for the 164 statement. My humble submission is that as per 164 statement, my lord, perhaps, my lord, the name of the present petitioner is not there, my lord.
Yes, no, they are.
It is a long, slightly complex kind of statement.
Singapore in a closed room, thereafter, my lord.
Same place, another place.
Thereafter, nobody from, nobody to Dhuburi, thereafter, my lord, from Dhuburi to Arunachal Pradesh, my lord. Thereafter, Arunachal Pradesh, where the victim was.
Recover.
That is the my lord, one aspect, my lord.
And regarding forcefully established physical relationship against one, saying is also there, my lord.
And regarding the present accused, he assisted the main accused person moved by the. Case 11. 32 case diary no proceeding. Some kind of aggravated offense, right? It's in POCSO, but uniform person. Like alleged to be uniform person. Petitioner, uniform person, not his military, DSF. So POCSO is an aggravated. Not POCSO. It's not POCSO. So in a way, aggravated. Nevertheless. It is, the case diary is called for not yet received. Petitioner is in intent. Issue fresh requisition, interim bail granted by the order dated 10/7/25. Since extended till the next date of listing, next date of listing. So, fix on list after vacation. Yes, list after vacation. You suggested the 23 can, 23 can.
Last order, this year has been possible. This year has been missing.
Okay. Last date only came to know that investigation was completed. Yes. But so since there were certain allegations, stabbing, stone. You have got it this year. So the we'll take it after some time. If time does not permit, then we'll take it up, fixed from tomorrow. Monday. Monday. It is submitted by the additional PP that no scan PCR has been received. But we need some time to peruse the same. And 6 another date. List the matter on 22/9/2020. The interim bail granted by the order dated 19/9/2025. Cell. Only, I think it was given to 2, right? Yes, only 2. The interim bail granted to petitioner number 2, Minara Begum. Shall continue till the next date of listing. It's Monday. Yes. Yes. I say. Monday, 31. 36.
The medical report was called for by around 4/9/2020. After the interim was granted, the petitioners appeared before the hour.
Medical. Serious injury. Serious injury.
That medical report, the case there, only physical assault, plus early on accident on Bedra, account plus what is here.
These documents are available with the case. Then
Injury of head and the chest. That part is here. But
previous injuries,
that is
not label categories.
that's why the specific medical report is required, because yes, injury of the yes, I nature of injury and the weapon.
So that is why we call for the
Yes,
That's
specific
in fact, that was the query on the
medical report.
the nature of the.
The petitioners were granted interim bail on 6/8/2025. a person to which they are stated to have appeared before the High and their statements recorded. This full stop. The same is confirmed by the learned additional. You have entered appearance today. You have a good name. He does. Learned counsel appears today on behalf of the informed and submits certain documents containing that pursuant to the assault, the victim sustained serious injuries and he was treated in more than one hospital and eventually admitted in ICU of ICU of North Guwahati multi-speciality hospital. That is, but anyway, so however, it appears that to determine the nature, exact nature of the injuries, specific nature of the injury, specific nature of the injuries, detailed medical report was called for, and it is submitted by learned additional people. So Gosan that is not yet received. So should we wait for it? We call for it. Then again, the injuries are also serious. So issue fresh requisition for the detailed medical report. Of course, I will not cancel the entry. Also, this is for the informant side. Let us have it since he has got rightly or wrongly. The interim bail granted by order dated 6/8 shall stand extended till the next date of listing. When should I list it? After vacation. 17. Are you agreeable?
38 and 39 also are the same.
Just to list the matter after
17th.
on
17th.
17th. This is also AB.
April.
Both or AB. So it will be similar order.
Similar, 38, 39.
36,
36, 38 and 39.
36, no, 36, 38, 39. Same order.
Careful.
What about 37? The journey. FSL report. Oh, opinion is different. Homicide case. Homicide. Case of suicide. Okay. The FSL report was called for, but it is submitted that same is not yet received. And the prosecution seeks another. Prayer is allowed. The FSL report may be procured. List after you are for the informant and learned counsel. Assisting for the informant. Apparently, it's a. This is another dimension of this will be abatement because threatening to share some private persons. Maybe it can drive any, especially a woman, any person to desperation. But that's a very there is something eligible there. So list on restricted. Next week or after? There is no entry. Before vacation. List on 25/9/2020.
I am on interim, my lord. There are 7 petitioners, my lord. My lord, I am only limited prayer, my lord, today. I am seeking some extension to appear before the IO, my lord.
Okay.
Because of this,
Oh, that it's come for the IO, the IA.
I have filed because of some reasons, my lord, we couldn't appear. 2% we have appeared, my lord, but the rest we couldn't appear, my lord, because of the health condition of the 2 petitioners and the one's daughter is in hospitalized, my lord. And other 2, my lord, because of some business purposes, my lord, they couldn't appear, my lord. So I pray for a limited extension of the prayer, my lord. Let it come, my lord, after vacation, my lord. Will appear in the meantime, my lord. That's all. My lord.
In AB number 1987, IA to be. IA, 10. In the main bail application within bracket AB 1987 of 2025. Only one petition, several petitions.
7 petitions.
The 7 petitioners therein were granted interim bail, interim pre-arrest bail by the order dated 19/8/2025, while calling for the case there. In this context, Learned India Council, AM Bora, assisted by the budget, submits that while 2 of the petitioners, let me give their names, others who appears.
My lord, Nikhil Botra,
I'll just. Bajrang Botra and
Sunil Kumar, sorry, my lord. Sunil Kumar Singh and Roshan Yadav appeared.
Sunil Kumar Singh and Sunil Kumar Singh and Roshan Yadav appeared. However, the other 5 petitioners could not appear due to
Some
various reasons.
Yes.
Dash being medical, and some business related difficulties. Accordingly, the instant interlocutory application has been filed seeking 15 days time and 15 days more time to appear in terms of that order of interim bail. Yes.
There's a highest question in the other occasion also we will take to appear. Is there also all the English processes?
Interim bail, no apprehension. Anyway. I learned additional PP. He brought, SHS submits that. Submits and points out to the court a note of the IO available in the case diary that the petitioners have defaulted in appearance on earlier occasions. Learned Council submits that in compliance with the order dated, in compliance with the order of interim bail, the petitioners shall appear. Let them give them time. Case diary you'll retain or send back? Send back.
That's where it's sent with the person.
Yes, I. So 5 will need extra time. 5 will.
All 7, my lord, they will appear. All 7.
Again, they will appear.
They will appear.
These 2. It is submitted that along with the 5 petitioners who are seeking extension, the remaining 2 who had already appeared would also appear again. Accordingly, the prayer in the interlocutory application is allowed. All the petitioners are given additional time of, are you sure 15 days or take if you want?
My lord, after vacation, my lord.
15 days, they are seeking 15 days, but next time they should appear.
So that's why I'm.
If they want 5 days extra, it doesn't matter.
Yes,
The
madam.
appearance is more important.
Yes, madam.
4 weeks, madam. 4 weeks. 4 weeks. Is it okay? 4 weeks, any longer? Extra. The petitioners are given 4 weeks more time to appear before the IO and make themselves available for examination. The interlocutory application hence allowed and disposed of on aforesaid terms. I have to fasten order here also. No.
Interim will continue. Interim.
The interim, the interim bail, pre-arrest bail granted by order dated 19/8/2025 in the main petition, AB so and so, shall stand extended till the next date of this.
Oblige, highly oblige.
List, after vacation on 30/10/2020. So I'm not gone into the subject matter.
It's a civil dispute otherwise. madam. It's-
30/10.
Oh,
yes, sorry. The case diary is sent back and procured again after the latest updates.
Oblige.
Make lordship petition is in interim lordship. As per order dated he is appeared and therefore taken full stop. Should be said and accept as per office code.
CD not received. Case diary has been received. Scan. That means investigation is complete. South Salman. Use of the co-accused. What?
Many is possible.
Many.
Only one.
Oh, the interim. Yeah, appear before the court.
I take the trial.
Okay. Mr. Islam, Arislan, Learned Counsel for the petitioner and right order dated 26/8/2025. The petitioner was granted interim bail with a direction to appear before the learned court below, within bracket, additional CJ South Salman on 10/9/2025. And it is submitted that accordingly he appeared and received orders from the learned court with regard to the interim production. A certified copy of the order passed by the learned court in PRC 20 of 2019 on 10/9/25 submitted for perusal of the court. Scan TCR is received. Should we wait or should we?
Submit one.
Because they are missing the false comment of mails. Sure. Just. Either we extend the interim or dispose it of. Dispose it of. The scan TCR was called for, however, the same is not received. The circumstances in the circumstances, considering the compliance with the bail condition by the accused petition. I am also considered that matter can be disposed of instead of keeping it pending. Accordingly, the interim bail granted to the interim pre-arrest bail granted to the petition by 26 thereby made absent. Subject to the condition that it shall be available during the time and shall not hamper or tamper.
May submit one thing, Lordship. During the time of incident, Lordship, the petitioner was in juvenile, Lordship. Subsequently, we have submitted original birth certificate and other condition. Due to the pendency of this bail petition, Lordship, the court will not get petition something. So observation will be.
I'll record your submission. I'll record your submission. It is submitted by Mr. Islam, rather submits to all of the court is possible. That the accused petitioner claims to be a CICM. CICM, and however, while appearing at the time of his appearance below the learned court below 10/9/2025, this was not submitted.
Lordship, we have submitted, but it is not.
Oh, it's not. This aspect was submitted. This aspect did not get reflected. Right, in the order. So that's all. I know you are the petitioner. This petition is at liberty to raise plea of juvenile. He claims to be a CIC. I'm right to get anything. Then after that, or to be allowed to be submitted subsequent to this, the same sequence was allowed in this case. You take back this. You did. Stands allowed in this question.
It is why on interim bail, Lordship. In pursuant to interim order, he has appeared before the IO, Lordship. Lordship, may can see the FIR.
Injuries.
Injury, Lordship. Lordship, may can see at page now 15, vulnerable person. Here it there.
What do you submit? This there might have been grievous injuries also.
Injury, Lordship, simple in nature because Lordship.
We can still grant it, but that can be saying.
Yes, Lordship.
Description is like that.
Yes.
But if it is simple, it is an important fact in your favor. Any
Yes.
comment?
Yes, Lordship. While granting bail to the other two accused persons, regular bail, Lordship has observed in the order. Lordship, para 5 reveals simple injury. The allegation is of Lordship grievous injury. They have been also already enlarged on bail, Lordship. This petitioner is on interim bail. Lordship.
The present petitioner was granted interim bail on 28/8/2020. Learned additional PP Goswami submits that in the meantime, charge sheet has been submitted on completion of investigation. The petitioner, learned petitioner counsel places before the court order this court passed on 22/8/25 in BA 2591/22, granting regular bail to four accused persons, in which the submission of the prosecution was recorded that the medical report revealed simple injury. Keeping that aspect in mind and also the completion of investigation, the interim bail granted on 28 is hereby made absent. So the condition will be available for trial. Shall not hamper or hamper.
Deeply opposed.
Suppose to allow it's possible. Next.
Well, this petitioners are on interim bail. Will already appear before the High Court.
Well, there is the order by which interim order is. Darius receipt. Yeah, officials of Punjab National Bank.
Yes. The ancient petition was one, two, so because they are signatory authority.
Answer.
Casually given their statements, just reading their statements. So I serve as a manager of CSC Diplomats, Punjab National Bank, and you hear myself as he is a clerk of Punjab National Bank, who is a mere culprit, same transactions, just manipulated to customer accounts. I never verified any debtors which I received from such. Later on, after that incident, I came to know that this gave us fake letters to transfer them different branches reimbursement. I had never verified the signatures, which was on the letters, and it has seal of system without any verification to transfer the money. So if it is strongly transferred to any branch, then it should return to our receiving department. Instead of that, the money has been transferred to Saskia, right? There was so many speaking the other banks. So being the signatory.
Bit reckless. No, being little, not little, actually, being reckless.
Reckless.
Being
So same statements
attract
by the other petitioners.
departmental proceeding. Whether is my criminal culpability, we are on criminal culpability.
That's also a point. No, yeah, as you know, in service matters, for banking officials, the standard of diligence and conduct has been held to be high.
That's all
Or
right.
Supreme Court.
I agree. But that will,
No, I'm not, I'm not saying that you're wrong. I'm saying that disciplinary
Exactly.
proceeding also, it is standard is high.
absolutely.
But,
absolutely. Not denying of
but because see, place yourself in the shoes of the victim. Other people's money is there. I can do whatever I want with my money.
Absolutely. Can you see this FIR? Can you see the, can you peruse the FIR? Can you peruse the FIR?
The non-customer accounts.
by putting forced signature. By putting forced signature.
Like,
How are you supposed to do that now?
During the cross check, it's on the part of the petitioner's responsibility. So the part has been transferred to the.
Negligence, we attract departmental proceeding. Not criminal culpability. Absolutely no criminal culpability. I'm not a party, not privy
So
to
we
these
did
matters.
publish. So that's.
No, negligence can give to process department. What is 3048? Is negligence giving, depends circumstances. But I'm not saying that. They have appeared, fine. I'm not saying that we have to cancel the bill.
But that is not a true satisfaction.
That is true. So people have to be, suppose tomorrow I say that I, without cross-checking that typing, I blindly signed out. I'll not be able to defend that.
The
It's
society,
my duty.
justice,
It's a solemn duty.
society at large.
That's true. It's okay. Confirming the, they have appeared, yes, but officials may not be, the officials themselves may not be in pollution. It may be a case of, absolutely. It may be a case of,
I may be
it may be a case of carelessness. Carelessness, but some places, positions you can't afford to be careless, like. Thank those people.
That's why I'm saying, man, that will expose me to department
otherwise-
process. I cannot avoid that. I will face it.
Definitely. Right order dated 28/8/2025. The petitioners, one petition.
Three petitions.
Okay, the three petitioners herein were granted interim bail. With conditions. And for the reasons noted in para 6 and 7 of the order. It is submitted that pursuant thereof, the petitioners have appeared and their statements have been recorded. This is true.
Yes.
The same is confirmed. Obviously, in Revit, same is confirmed by SH Bora learned additional people. So, however, the learned additional people submits that from the statements of only one you are pointing out, the others also, on statements 1 and 2, the petitioner number 1 and 2. It is revealed that they, in the matter, in the concerned matter, that they conducted themselves with gross carelessness. And therefore, the prosecution has some objections to the grant of bail. Nevertheless, they have seized some documents, it seems. They must have seized. Nevertheless, in the circumstances, I do not deem it necessary to cancel the interim bail. And accordingly, the interim bail granted, the right order date so and so is hereby made absent, subject to the condition that they shall cooperate with the remaining investigation. Semicolon, tamper with evidence or try to influence witnesses. And otherwise cooperate with the process of law. This condition is not necessary. Huh?
Respect to petition number 2, she said from respect.
Telling from respect.
Once local surgeons.
Hmm?
Local surgeons.
2 sureties in that case.
Yes.
No, this
Please we need to respect.
It's from Jalpaiguri, yes.
in the order of he's already gone bail. He's already appeared with yes, given the surety. He's already provided the local surety. No need. No need. Yeah, it was regular bail. It is pointed out by the learned prosecution that in the order of interim bail, it was directed that once one of the surety, there will be one local surety. And the petitioner side submitted that has been complied with. bank officials. No issues. Times have changed actually. Nowadays, only, I know, some wood cutter in a deep forest can abscond. Actually, we cannot abscond. Can I abscond? My record is everywhere. We have Aadhaar now. These are things actually. Everyone can be tracked. Technology.
Yes.
I'm a serving official. But some people can, if you're in a deep forest or someone, wood cutter. Maybe even he has Aadhaar. If he's a voter, he's a. Anyway, the petition stands loud and disposed of. Return the case.
Wait for the. Here is bail application number. Where is it for not? Page number 15. That is a vernacular.
Nobody, right?
Dhubri matter. Basically, it's a case of attempt to murder, 109 BMS.
Should we read that?
Huh?
GMCH? Or.
If I may summarize the incidents, basically what happened was that, but
Can I adjust them? Yeah,
well,
get it checked.
yes. But basically what happened, two boys, that is the present petitioner's mother, and the victim, alleged victim, man, they, along with two girls, man, they went to Kalahat overbridge, man. And they were shooting some videos, my lord, in the evening. Some local people, my lord, objected to that. And some of them, my lord, even started to assault these boys. So this victim, my lord, what he did was that he jumped up from the bridge and he landed on a hard surface, my lord. There was no water under the bridge. So thereafter, my lord, his parents came, my lord. And then, my lord, he told his parents that it was his companions, that is the present petitioners, who had pushed him from the bridge, man. If your lordship will kindly see the FIR, madam.
Yeah, I'm on that.
If I.
Page 9.
Yes,
Then read.
page 15, if I may read this. 15, the vernacular.
Okay. Read them.
The item 47, my lord. Item 47, I know. Item 47.
47 is this one.
Yes.
Connected?
Yes, connected, same. I have. Page number 15. Shall I read the translated or the vernacular?
You can read the vernacular.
Vernacular, it's not a problem for us. সন্মানপূর্বক বিনীত নিবেদন এই যে যোৱা 11/4/2025 ইংৰাজী তাৰিখে মোৰ সৰু ভাইটি শফিকুল ৰহমান, that is the victim man, আমাৰ ঘৰত ফুৰিবলৈ আহে। উক্ত দিনাই নিম্নলিখিত পদকীয়া গণে ধুবুৰী লগত ফুৰিবলৈ যাম বুলি ফোনযোগে মোৰ ভাইটি কালাহাট অভাৰব্ৰিজৰ ওপৰত মাতে। সেইমতে ৰাতি 8টা মান বজাত মোৰ ভাইটি কালাহাট অভাৰব্ৰিজৰ ওপৰত আহে। পদকীয়া গণে 4চকীয়া বাহন দেখুৱাই মোৰ ভাইটিক উঠিবলৈ কয়। মোৰ ভাইটি গাড়ীৰ ওচৰত গৈ গাড়ীৰ দৰ্জা খুলি দেখা পাই যে গাড়ীত দুজনী ছোৱালী বহি আছে। তেতিয়া মোৰ ভাইটিয়ে ছোৱালীৰ লগত মেলাত নাযাওঁ বুলি কয়। লগে লগে আসামী দুজনে মোৰ ভাইটিক লগত কিয় নাযাবি বুলি কৈ তৰ্ক বিতৰ্কত লিপ্ত হয়। আসামী দুজনে মোৰ ভাইটিক মেলাত নগলে মাৰি পেলাম বুলি কয়। মানে is it believable, my lord, a person who does not want to go to a mela, that he is threatened that he will be killed, my lord. আসামী দুজনে মোৰ ভাইটিক মেলাত নগলে মাৰি পেলাম বুলি কৈ অভাৰব্ৰিজৰ ওপৰৰ পৰা পেলাই দিয়ে। লগে লগে মোৰ ভাইটি অসুস্থ অৱস্থাত মোক আৰু মোৰ ভাই ছয়দ আলীক ফোন কৰে আৰু কয় যে মোক ব্ৰিজৰ ওপৰৰ পৰা পেলাই দিছে। লগে লগে মই আৰু মোৰ ভাই আহি দেখা পাওঁ যে মোৰ সৰু ভাই শফিকুল ৰহমান গুৰুতৰভাৱে জখম হৈ অজ্ঞান অৱস্থাত পৰি আছে। লগে লগে 108ত ফোন কৰা হয় যদিও পলম হোৱাত বাবে অটো ৰিক্সা ভাড়া কৰি ধুবুৰী DMCত লৈ যাওঁ যদিও ডক্টৰে GMCHলৈ উন্নত চিকিৎসাৰ বাবে প্ৰেৰণ কৰাত প্ৰাইভেট এম্বুলেন্স ভাড়া কৰি গুৱাহাটী মেডিকেল কলেজলৈ লৈ যাওঁ। বৰ্তমান মোৰ ভাই GMCHত চিকিৎসাধীন অৱস্থাত মৃত্যুৰ লগত যুঁজি আছে। ভাইটিৰ চিকিৎসাৰ লগত জড়িত থকাৰ বাবে এজাৰিয়াত পলম হ'ল। Kindly see the grounds, madam. a person who does not want to go to a mela, he is threatened by the accused person that he will be killed, my lord. Can that be a reason, my lord? So basically what had happened was that they all were complicit, my lord. They all went there. They were doing something, my lord. The locals objected to that. And this boy, he jumped off the bridge to save himself. And then, my lord, when his parents came, he said that no, because he cannot blame the locals, my lord. He put the blame upon the petitioners that it was the petitioners who were threw him from the bridge. That is the case, my lord, actual case. Wow, my lord, we are not an interim, my lord. If the lordship gives us an opportunity, my lord, can go and appear and record our statements, my lord, because then, my lord, our side of the story will also come, my lord, on record.
Diary is received, but medical report will be necessary. Medical report will be necessary. Medical report will be necessary. Mhm.
Well, we will definitely implicate, well, but what will be the motive behind that, man? There must be some motive, man. Not going into a mela cannot be a motive, man.
Can I have a look? You want? Or you, if you want to make any submission, you can make. Do you want medical report? Actually, court also needs.
Yes.
Just 482 bail application. Thinking. Here is case for motives of this. In connection with VPS case number 214,000 section 24. The case arose of Aadhaar and Aadhaar dated 19/4/2025. Lost by one Sonali Devi. Stated to be the sister of the alleged victim. It is alleged that the accused person asked him to come to one bridge near Dhubri. When he went there, he found him in a vehicle with two girls inside, whereupon he expressed reluctance to accompany them. That, this led to an altercation, and it is alleged that if he does not go to the mela, they would kill him. It is further alleged that pursuant to such altercation, the accused persons threw him off the bridge, resulting in injuries. Heard as thus learned counsel for the petition, assisted by a good name. Counsel. The learned counsel submits that the narration in the Aadhaar is distorted and highly exaggerated. It is submitted that the real facts of the case is that the victim along with the other persons were doing some filming / photography on the bridge near Dhubri, whereupon some locals objected and leading to an altercation between them. And in that situation, he jumped off the bridge himself. When his parents came, he said that he was thrown off by the accused persons. Nevertheless, DP Goswami learned additional PP submits that though case diary has been received, but the medical report has not been received. The learned additional PP has flagged the statement of witness. He is the victim. What is the girl?
The girl. And victims are the girl.
Like it is submitted by the learned prosecution that the victim has implicated the present petitioner seeking anticipatory bail. One of the girls has said like this, they were all tried to catch. So anyway, perusal of the medical report is necessary for proper adjudication of the bail. Therefore, the case diary may be sent back and medical report may be requisitioned by the prosecution. However, in the meantime, the accused petitioners can be given an opportunity to record their version of events as contended by the learned petitioner counsel. Therefore, in the interim, in the event of arrest, 20,000, there's one petitioner here.
One petitioner, madam.
The event of 20,000 with one zero, like, the satisfaction of arresting a problem, subject to the condition that they will cooperate with the investigation, semicolon, appear before the IO to record their statement. And semicolon, not hamper or tamper with the evidence.
Same for item number 46 also.
Same one.
Same one.
Item number 46. 47 also.
47. This is 47.
Oh, this is 40, it is 47. It's 47. AB 1747. 212105. Girl has stated about 5 persons together. Were, and the record is
Hello.
that progress by investigation.
Hello.
List after the petition on
2910.
Hello.
okay
Mile.
29.
What's the clearest way? I guess he was person.
Not case that. The allegation,
Worship, case 11 people,
I'm on that team. So, robbery.
Worship.
Robbery.
Accused number 1 is to arrested. I am for accused number 4 and 5 also. I have also annexed a lordship providing report, annexed 2, page 17, lordship, and page 19.
Okay, this is the forwarding of 1, 2, 3.
1 and 2,
1 and 2.
lordship. I am for 4 and 5.
Yeah, got it.
Worship, may I submit one thing, the petitioner may be protected and they will cooperate with the investigation, but
The allegation is their name serious. And they are named also. These kind of things are very, very grave from the view of public safety, house trespass at night, booking, highway robbery, financial. Maybe. So,
yeah, morning 8:30.
now can you get the diary before vacation? Can you try?
Like 25 days.
Let him try.
Or like,
Is diary not yet received? Issue fresh requisition. Fix on 25.
Midnight. Yes, there is.
This is connected, no?
no.
Right.
It's from
Okay.
lordship, and here allegation lordship kindly have a look at Aadhaar is 30.
118 years there. Previous very police required.
वहाँ पे cases. Medical report is made, not received, right? Not received. No, what was report? What was?
Is there an along with injury report?
Case diary along with injury report was called for. Considering the nature of the allegations. And stuff. However, it is submitted that the same is not received. Issue fresh requisition,
Petty political case for biography, 25 times.
25 same.
Nine.
25 nine. Order.
In this case, Lordship, we have filed this petition for quashing of a proceeding, Lordship. And in this case, the main allegation is we have availed a loan from a finance company, Lordship. And we have defaulted in making payment. The main allegation is defaulter in making payment, Lordship. And the vehicle which was hypothecated to the respondent number 2 was not produced. That is the main allegation in the FIR, Lordship. But after lodging the FIR, the charge sheet was filed under section 420 and 406, Lordship. And in the meantime, the company respondent number 2, who was the informant in the present petition, he transferred the distressed assets and liability of the company to the respondent number 3. My friend is appearing for the respondent number 3. And after that, Lordship,
Stressed assets, stressed assets.
yes, stress assets. And we have already paid the payment which was due to the company, and we are issued a Lordship a no due certificate. And your Lordship will find that certificate is at page 30. There is no claim as on date. The main allegation was not payment of dues, and we have already paid the same. And there on the basis of a compromise between the respondent number 3 and the petitioner.
Got it. Yes, it has come for what? Why is orders? Orders it's come.
Is it not dispose of it today because my tell perhaps no objection in this regard. The matter has already been settled between the parties and we have paid the dues.
Yeah, you have submitted that. It does not take much time, then we can, why not? Yes. Bails are over. For 2 and 3, you are appearing for 2
I'm
and 3.
creating this, I just for respondent number 3.
2?
Who might not
See you there, actually, upcoming purpose.
As regards to compromise in the payment of due period as amicus had on that part, so I will be unable to assist you on that part. However, when I come to the FIR, this is basically regarding a hypothetical agreement. The excavator is hypothecated and the allegation is regarding the non-payment of.
And therefore allegation of cheating is there.
They have brought in a criminal breach of trust and cheating, 406 and 420. As far as we know, 420 is concerned, 420 final the same submission not be attracted because that would be predicated on presence of a dishonest intention at the
Yes.
time when this hypothecation agreement.
But it was transferred pursuant to hypothecation.
hypothecation. So unless and until there are materials, my lord, who show that at the time of execution of the hypothecation agreement.
It was executed with a dishonest intention. Right.
As regard my lord, entrustment, criminal breach of trust, my lord, then it is covered by a judgment of the Honorable Supreme Court.
Yeah.
2006, 667, 36, my lord, Indian Oil Corporation versus
NEPA.
NEPA, my lord. So there, my lord, paragraph 21 to 31 says that when there is a hypothecation, my lord, only this entrustment, the concept of entrustment is not there. So if there is no entrustment, the foundation of criminal breach of trust goes away.
Entrustment is the key.
Key, my lord. So without entrustment, so 406 should also not be attracted. Going back to that was also a case, but I mailed a copy of the judgment, my lord.
But 406 and 20 are also
Also, my lord, mutually
Incomplete.
exclusive, my lord.
race club. Delhi
These are
race
the
club.
issues. Why? All
Misappropriation can be perhaps.
402. But again, my lord, 403 also. 406 will not be there because by the going by that judgment, whether 403 is there or not. Is one thing which is there that they have mentioned regarding the initiation of arbitration proceeding. That again, my lord, is settled that just because there is a law for arbitration does not necessarily extinguish criminal life. So that part we will not get the benefit of that. At the end of the day, it all boils down to whether there is misappropriation or the.
Yeah, that's true. But if the amount has been paid back,
That's what I.
if it can be confirmed, then we can definitely consider it. So, should we wait for, we can, Who's appearing for the respondent number two?
Pico. She was there, perhaps the.
After the. If possible, we'll discuss it. Yes. You open this.
Orders. May it please your lordship. What's the application for suspension of sentence for bail, lordship? If the appellant was convicted under section lordship for two offences. One lordship under section 307 IPC, and he was convicted for to suffer rigorous imprisonment for 5 years. The second count lordship 498A for 1 year. Both the sentences were directed to run concurrently, lordship. Lordship. Now, lordship, total period of detention of the applicant is 392 days. Around lordship 1 year and 1 month.
Just a minute.
Lordship. So,
Just a minute. You are appearing for the wife, Jamini.
mother-in-law is the lordship informant.
Sorry, madam, I guess in the urgent matter. Here I am appearing for the respondent number.
Oh, as a private. counsel.
Privately.
No,
Lordship, you can see the appeal memo. Page number 17.
I have gone to the sentence.
Lordship.
He's undergone
Already lordship total 392 days.
more than a year.
More than a year. 1 year, 1 month almost.
Prosecution, I'll quickly hear your submission.
This is lordship the second occasion the matter has been fixed for lordship consideration. His father and mother also faced trial. They were acquitted.
Who was attempted to be assaulted or attempted to be assaulted? The
Wife of the applicant.
and it was lost by,
Lost by the mother of the wife.
she's alive. Wife is alive.
Ella.
And it was mother.
77.
So she did an IA for suspension of sentence, remember? In the second IA, that one was rejected on 20/08/2024, matter. The applicant is behind bars for 2 years, 8
Same
months,
bench.
2 years, 8 months, 12 days.
Same court, I think it has to go. Just a minute. Come to me.
Here for the 10 years. Yes, 10 years.
This was rejection was by Pathak sir. So that principle only applicable. This is not there, but this will take more time.
More time, I have to go through it also.
Yes, because it seems. So can we have it in another?
Another day.
Another-
Maybe fixed, my lord.
Huh?
Kind of good to know.
Oh, that is,
10 years condition.
that's a procedure. Good stuff. Yes, land council for the applicant, Goswami, additional. Good stuff. It is submitted by the larded prosecution that they seek to file an objection. Considering that section is two section. Okay. One of the sentence under section 304 is of 10 years.
For the 10 years.
Also 10 years, 10 concurrent. The sentence is of 10 years. Sentences of 10 years, each under 304B/306. Case record has been received. The prayer is allowed. List, some list.
The date may be given by.
List after vacation. After vacation.
Any date, madam.
29/10. No problem?
No, that's all right.
You tell me, if you can take.
If my lord,
Plus minus will be.
22, 23, my lord. Twenty-two or 23, my lord, if possible.
Yeah, up to him. If you can accommodate. No problem.
22, man.
22/10.
Much of it.
51 pending.
No, no problem. Can't make two courts at the same time. Okay, so that matter. He's appearing for 3. You are representing 2. Married council submitted about some agreement. Make your submission. And you are. Pardon? I don't know. Kindly help me with the documents so that I can. How many official matters are there? Jonas and Volvola, it has. Supplement. But it had come to order. It's come for orders. Should we try dispose of or? If it's yeah, if it is a short order, then it will be justified. Otherwise, just it takes time. So if it requires time, then it will, because otherwise, as I understand from his submissions, that this it seems to have private facie merit. It's settled him. He also has no objection.
Can be fast and because there is also agreement between the two parties.
That also. Okay, so I'll start the petition. You help me with the documents. And sit down. Necessary. Instant. You, Mr.
B. Haldar.
B.
Haldar.
Haldar. And counsel for the petitioner. Heard. P. Kolita. Learned counsel for respond number 2. S. Nawaz, who has been appointed as amicus curiae for the respond number 3. The petitioner, Nobodeka, is seeking, is invoking the powers under section 482 of the CRPC, 1980, the CRPC at the time, seeking quashing of the charge sheet number 484 dated 17/9/2023 filed against him under 406/420 IPC. Oh, then the charge sheet he gave 406 and 420. Could have been 43 because 403. Under 406/420 IPC. After investigation of dispute PS case number 1959 of 2018. Within bracket, TRC case number 1330 of 2024. Payroll, the Aadhaar dated, FIR dated 26/2/2016. Lodged at Sadgaon PS on behalf of on behalf of the L&T Finance Limited. L&T Finance Limited.
Also, we'll find the type copy of the FIR is a case.
No, I'm going through it. The gist of the allegations narrated in the said FIR is that the petitioner as a borrower approached the finance company for purchase of one JCB and upon agreement, the company sanctioned total loan, sanction loan for purchase of the same. And in this regard, loan cum hypothecation agreements was dated 21/3/2011 was executed. And the loan amount of loan amount was rupees 21,18,600 to be repaid in 35 monthly installments. And in the event of the failure, the borrower and guarantor were to be liable to pay overdue compensation at the rate of 36% per annum. It is further alleged that right from he paid some amount. Did he pay some amount? Because they have been irregular in payment of installments.
Irregular.
He did not pay anything or
Irregular payment.
which alleged that
next page,
right from the beginning.
yes, page 15, which comes
Right.
around 21,50,000.
Right from the beginning, the petitioner as borrower was irregular in payment of installments. And continued to fail to do so despite requests and reminders. It is alleged that arbitration proceedings were initiated and he did not appear in the same also. It is also alleged that the asset which was the subject matter of the loan was also misappropriated by him. The company claimed a total pending amount of rupees 21 lakhs to 56.31. Then what about this one? Future loan installment? This is inclusive. Inclusive.
Yes, yes.
Inclusive.
Inclusive.
The total amount. Along with the interest at the rate of 36% per annum in terms of the agreement. The company alleged in the FIR that the act of the petitioner also amounted to criminal offense of cheating, breach of trust, and misappropriation. On the basis of the Aadhaar, this PS case 1959 of 18 was registered under section 406/420 IPC, which after investigation resulted in a charge sheet under the same penal provisions as already stated above. The accused petitioner is now before this court seeking quashing of the said criminal proceeding, including the charge sheet. It is further contended. Where have you written this? In the additional affidavit? Subsequently, by the order dated 4/6/24, the learned SDGM number 2, Kamuk Metro, was also pleased to take cognizance in PRC case number 13203 based on the said charge. There's the order of stay, I think. Yes. The the said proceedings are stated to be under an order of stay. It is submitted by the learned counsel that in the meantime, the petitioner, this petitioner has paid the entire amount. Entire amount in installments.
Due certificate was.
And in this regard, now you help me with that document. In this regard, what is this power of attorney? Yes, in this regard. We'll make it short. You just help me with them. The pages. Paragraph page 30, the no due certificate issued by the transferee company. Last line, this letter may be considered as a no due certificate and we confirm to have received the full and final payment of the amount. Pay the amount by settlement. In this regard, as annexed as annexer 3. A new no due certificate. Kotak Mahindra Bank, it's now L&T Finance.
This transferee company.
Hmm?
So, initially,
L&T
loan was available from the L&T Finance.
Hmm.
Subsequently, L&T Finance transferred listed loan and liability to the respondent number.
Oh, I see.
And
It appears that subsequently, the loan account in the form of a stressed asset, the defaulted loan account in the form of a stressed asset was transferred to the Kotak Mahindra Bank. Full stop. The learned counsel has drawn the attention of the court to Annexer 3, which is stated to be a no due certificate dated 29/12/2023, issued by the said bank to the petitioner, stating that the letter may be treated as no due certificate and it confirms that they have received the full and final settlement, the amount payable by him by its settlement agreement dated 29/3/2019. Yes, it's long.
no, dated 29 December 2023.
This is the date,
Yes.
assignment date, assignment agreement dated
Assignment agreement 29 March 2019.
19. You have annexed that. Have you annexed it?
Lordship, kindly compare page 30 with page 14. In the FAR also, they had mentioned the contract number, Lordship. Yes.
Okay, no problem. There's agreement on the other side. Any submission from the side of the state? What are any who's appearing, who represent state kind of formal. But since Chashid, we bought to learn additional people. You have what should be your submission? Submits that. Should I record your submission? It will be my submission. You can submit. Yes. Considering the materials from yeah, you can, it can be something like that also for the prosecution. Just say, can be disposed of as per law if the court is satisfied about the agreement. Something like that. Yes. It is submitted by the learned prosecution that since the parties claim to have arrived at a settlement, it was on the cluster over this. I mean, the matter may be disposed of by the court as per law. The court may dispose of, the court may pass necessary orders as per law. Dispose of. Yes, Nawaz learned counsel representing the authorized manager litigation of the L&T Finance. Sorry, Kotak Mahindra.
There's one issue, my lord. It's an agreement.
Yeah, we should not get,
Certificate.
go wrong actually.
Certificate is going to submit to the client.
Pointer bank.
Pocket line, not by LL. Because the loan was initially with LL, it was transferred to pocket line. Now, as far as this notice certificate is concerned, there's a because I will not be able to either verify or submit it.
In that case, it will be part of.
Because they did not appear. Because of their, they did not appear, so I was a competent member. So on fact, this part I cannot.
True. Your instruction is that it is settled. It is settled. Settled. The learned counsel appearing for respondent number 2 dash within right authorized officer / manager litigation L&T finance does not dispute the contentions of the petitioner side and confirms from the side of the state finance company that the matter has been settled as indicated by the petitioner side. That's okay. No problem. But what to do then? This part.
Because they have also not appeared. So adequate opportunity was given to them. They have not appeared. This was but they did not appear. So only on that aspect, we record that as amicus, I am able to verify this. So whatever the petitioner has submitted, along with what
Can be accepted. Can be accepted.
Right.
Mr. Nawaz, learned amicus curiae clearly submits that despite being given sufficient opportunity, the respondent bank did not appear. Whereupon he was appointed as amicus to assist the court. And therefore, he does not have direct instructions. He would be unable to confirm on the basis of any direct instructions. Stand of the bank in the regarding the settlement. Stop. Going back to the initial facts, I find that the FIR was lodged on behalf of L&T Finance. And the learned and the said respondent informant to its learned counsel has submitted its no objection to the prayer of the petitioner based on the settlement. And has submitted and confirmed about the settlement between the sides. It appears on the materials and the submissions that though initially loan was advanced by the L&T Finance Company, but subsequently the loan was transferred to the Kotak Mahindra Bank. Settlement was with the bank. With the bank. It is contended and submitted by the petitioner side that the agreement submitted by them is bona fide and should be accepted as the respondent bank has not come forward through its own counsel to controvert the same. So it is settled. Should be the law of quashing. Next paragraph, short paragraph. The law of quashing pursuant to settlement as crystallized through the cabinet of decisions of the Honorable Supreme Court. One of the earlier decisions was rendered in the state case of Gyan Singh versus so and so. The law was further developed in the case of Narendra Singh. Some more parameters, especially with regard to certain serious matters, were laid down in state of MP versus Lakshmi. In the given situation, in the given facts and circumstances of this case, apart from the dispute being prima facie a civil one, which was also subjected to an unsuccessful arbitration, an unsuccessful effort at arbitration, arbitral resolution, unsuccessful attempt at arbitral resolution. It also has to be noted that pursuant to the agreement between the agreement and the contentions regarding no objection on behalf of the informant side, continuance of the criminal proceeding would be a wastage of time and an abuse of the process of the court and its valuable time in a situation of overloaded docket in the criminal courts. Therefore, in the given situation, I find this to be a fit case to exercise the power of quashing on the section. Now I should use the DNSS. Accordingly, everything has to be quashed. The PRC case number 133024, the charge sheet dated all the proceedings of the entire proceeding of PRC so and so, inclusive of charge sheet number 484 dated so and so, arising out of this are hereby quashed. Pending in the court of SDGMS number 2 hereby quashed. The instant criminal petition stands allowed and disposed of on the court's terms. The court records its appreciation for the services of the learned amicus school, who shall be entitled to his usual fees. As regards this agreement, I am unable to verify. Yes. Around line it is contended by the learned amicus that since he does not have direct instructions, so he is unable to confirm or dispute the agreement placed by the petitioner side. It's okay. Thank you. Another day. No problem. Even I seek accommodation because there's a full court meeting. So I have to rise at 4:30. So you also seek another. All three of us need adjournment.
Next time.
The matter could not be taken up due to paucity of time. It's like fixed. List after vacation on. You suggested
Possible, before vacation.
no, please excuse overloaded. Priority should be bail before vacation. 14th of October, 14th or 15th. It can be a little later also. I don't know what is the matter or it's any urgency there. I don't know. Okay, 14th. Depends on.
Anyway, it's
22. 22 much. 20 to 10. Right.
So regarding quashing of a ballot, charge sheet ballot, the other ballot, the respondent appeared ballot, they filed an affidavit ballot,
Informant has appeared.
ballot. They have settled the matter ballot.
Will you be able to complete?
Yes, that's the one. And only problem is that ballot, the next date fixed before the court below is on 15th of October. Can it be prior on 14th ballot? 14th of October.
We are reopening on
We are reopening on 13th.
13th. So, yeah, when should I fix it? 14th.
Next date
Next
is
date is 14th.
15.
So, if unable to hear them, we can do interim.
Interim is there, madam.
Always there, already.
Interim, madam, so far, madam, the petitioner number 2, 3, and 4, madam. 1, there is no interim. The lordship previous, madam.
I don't know the subject matter actually.
Subject matter, madam.
We'll see on
Ballot, madam.
that day if it's,
On 14th.
then you mention, do something.
On 14th of October.
14th of October. Time constant, 14th of October. Yes.
Your Lordship, in this matter, Lordship, on the last day, the court directed the investigating officer
Yeah.
to produce the up to the case diary along with medical report and FSL with it.
No time.
Maybe fixed for hearing.
Full year. Full year.
An interim order passed at your share.
We can fix it. It's at the stage of admission, right? Let it remain in admission stage. We can try to dispose it if possible. If we cannot, do full hearing.
Should be.
Yeah. It will save possibility of time. What was called though? Case diary. Case diary. Will you retain it? Case
Along
diary
with
has been,
medical report and FSL.
okay. Case diary is received, but medical report and FSL not received. Received by medical report or along with FSL. Case diary along with FSL medical report shall be retained. So this is the matter on after vacation on in the admission column on 16th. Hearing date, will time. It is short matter. You point it out if it's what.
Interim order.
The interim order passed on. This is not a special report regarding the parties and the report regarding examination regarding death MP party. Ballistic report. Yes. Then broadly call it a forensic report. Broadly, ballistic report. Anyway, I will write like this report, CDN report. The interim order granted by the order dated 8/4, I think.
Yes.
Shall continue. Shall stands extended till the next date of listing. 16, the admission column. You point out it is short. I think I should stop because kindly point out mentions if any. If you have any mention because others leftover matters.
Yeah, take the idea by the other thing. Normally, in custody about 10 years from this case, my
Aye.
already about 2.5 years.
Mm.
Already time.
Take.
So, but the tricks already came out before that much of a thing. His father is very serious. Man. Father is very serious. Man. Like a 54. The come for hearing, but I say that when come, I is pending. Then the idea come. Then in the next one, idea one day.
Sit on 23rd. 23rd.
Alright.
Next week, all motion.
Fine, fine.
So,
I know your worship. You can come from order.
23-9 in the orders column.
Orders. Aye. Alright.
Item number 50. Whether is already compromised, large professional take could not be.
We'll conduct the hearing after vacation. Finish it.
Then they kick this.
Please suggest. Possibility of
October.
It is already in stage of hearing. List for here. List for hearing on 15/10.
1610.
16/10.
Lord, item number 14, my lord, it may be fixed a date, my lord, after vacation. Admission column. my lord.
14 list after vacation. On any suggested dates?
My lord, for 16, 17 like this.
How about 22nd? That's a motion there.
No, that's 22nd.
22nd. 15. Okay. 16. Or October. Oh, then it is holiday, 20th holiday. 22. Interim orders, don't worry. Wherever interim order is there, it will be extended.
Item number 16, my lord. With item, the victim is suffering since 2008.
2008. What is this? Like this maintenance matter.
Not maintenance, you know, but estimate should be more important. One part is compliant, another part is not. Extent of is all for you.
It will be, I can fix it, but before vacation, it will be very tight. Oh, can it be after vacation?
No.
List after vacation on, but immediately after vacation, I'll fix. No?
And for the petitioner, you watch it at this place, item number 16.
Oh,
There is an interim bill to.
there's an interim order in your favor. The interims will be extended. It's not your fault. Did not
Okay.
reach. So let it be on, can it be on 14th of October?
Yes.
Second day of reopen. 14? Okay.
So in respect to item number 17, Lordship, there is an interim order.
7. Interim will be extended. Don't worry.
Lordship, make
7 for the installment. Can it be immediately after vacation?
Yes, why not?
I think so.
16, Lordship.
16, yes, 16. 16, right, we'll mix up otherwise. No? Item 17.
Yes, Lordship.
Right? Item 17, list after vacation on 16/10.
Interim make continue.
This is also I have filed an agreement for suspension of sentence.
Mhm.
The matters come up for hearing, not for order. So it may come after petition.
Which item number?
Item 53.
55. Item 55, list after vacation. Date you want? Date?
Then, yes, that's it.
Can it be on 27?
28 or
28. 28. I have to go.